be a method of making access to justice available, or enhance access to justice, especially for the poor, for the indigent. So the study was based on both field study and desk review of the available literature. So field study, the research methodology was that data was collected from 8 stations within the country. The country was divided into 8 geographical regions. Each region represents the former province of Kenya. So from each region, 1 port station was picked, and the key respondents were judicial officers, judicial staff, advocates, mediators, and members of public who have had an interaction with court annexed mediation. So maybe one may wonder, what is court annexed mediation? As I've said, it's mediation happening under the umbrella of the court. It's limited to matters that are already filed in court, civil cases already filed in court. So the deputy registrar of the court, or magistrate, or Kadhi, as the case may be, goes through the matters that are already filed. And if he or she finds one that is suitable for mediation, the matter is referred to mediation. It's a process called screening. Parties are notified within 7 days. They are expected to file a case summary. The filing of case summary is not a must, but it's encouraged that if it's possible, parties should file case summaries. Then after that, a mediator is appointed by the deputy registrar. The mediator is supposed to convene a meeting of parties, between the parties or between the disputants, and the process commences. It's expected that within a period of 60 days, process should be over. It can be extended once for 10 days. If in any event parties are still talking and they're about to wind up the negotiation. So once a settlement is reached, the matter is referred back to court for adoption and enforcement. So once the settlement agreement is adopted, it becomes judgment of the court, and it is treated as such. Where there is no settlement, then the matter proceeds from where parties had reached before the matter was referred to mediation. So there is no appeal in this process, because it is reasoned that it's the decision of the parties by themselves. It's a win-win situation, so an appeal is not expected. I'll go to the discussion and findings. The impact of CAM, or court annexed mediation, on access to justice. As I have said, it takes 70 days maximum. Compared to litigation, we've been discussing about this. The study established that on average, a case takes about 5 years in Kenya. Civil matter takes about before me. Then it finalizes the process. As I say, there is no right of appeal, so the indigent are protected from the prolonged period of litigation, which is expensive in terms of costs. CAM is flexible. I find that in litigation or in arbitration with some formalities. There are rules of procedure which are complex, and it's assumed, expected that the poor person understands these procedures. The beauty of court and explanation that parties can express themselves in their language. They can choose when to sit, where to sit, and this can even be under a tree. Yeah? So this makes it easier for everyone. Calm means broken relationships, and the relationship that this has to the poor is that when people live in a harmonious, when people have a harmonious relationship, then there is no the future disputes are discouraged, and that way the poor are shielded from rigorous and expensive ways of seeking justice. So there are many challenges that are associated with CAM. In our related paper, we have discussed them in 3 thematic areas: that's procedural, institutional, and attitudinal. But for purposes of this discussion, we focus on the challenges that directly affect the poor. What do I say? What do I mean? Those challenges affect everyone. However, there are particular challenges that affect the poor. Challenge number 1 is that CAM is limited to civil disputes already filed in court. So for one to make use of CAM, he or she has to have his matter filed in court. This again, if we can remember what Dr. has just said in the opening remarks, there are many challenges. Filing a case in court for a poor man, a person who earns $1 a day, 100 shillings a day, is more concerned of putting food on the table. How is this person going to file his case in court? These challenges include lack of legal identity and knowledge of legal rights. So for one to be in court in the first place, this person must have legal identity and such like things. The poor or the indigent live in rural areas. Accessing these offices of registrar of persons is a challenge to them. So that already is a bar to these people. Then there are high costs of litigation and legal fees. On average, the study established that legal fees in Kenya take about 300,000 shillings. Opening of a court file of at the advocate's firm is about 60,000 shillings. And we are talking about this person who earns $1 a day. Obviously, is not going to afford. Then you go to costs of the case. Sometimes I have a privilege of taxing bills that are filed. You find that it's millions and millions of shillings. So basically the poor is just cut off. Then we have COVID-19 with us, and we've been advised that the situation will be like this for a long period of time. My senior lady, Justice Helen Wasilwa, explained to us the advantages that have come along with ICT. And I join her that indeed, we have made tremendous progress as the judiciary. However, there is this class of people that is left out. And our research establishes that the poor comprise of over 60%. My friend, was it Ndashiki yesterday? She gave us the statistics. So in as much as we are celebrating the use of ICT, let us remember these people who are the majority, 60,000 or 60%, sorry, 60%. E-filing, virtual court, mediation sessions. So you find that even having the gadget, having the skills is a challenge to them. So this cuts them out. Next, we have this understanding of court processes. In my opening remarks, I say that CAM is practiced in 12 counties. It is attached to high court stations. Where do you find high court stations? In cities and big towns. So you find that this person in the rural area, even where his matter has been referred to CAM, he or she has to travel, cover that long distance. In a way, the point I'm making is that the disadvantages that were associated, or the things that bedevil the adversarial system, are slowly finding their way in court annexed mediation. So the issue of long distance will still be there because this process is happening under the umbrella of the court. Then we have the disadvantage of resistance of CAM by lawyers, judicial officers, and staff. Yes, our field study established that in as much as we have some lawyers who have embraced mediation, a good number of them have resisted it. Yeah? In fact, one of the litigants who was interviewed, he had an advantage of going through CAM. One of the recommendations he made is that just chase away lawyers from this process. There are many reasons. When lawyers were interviewed, some of them say that really, honestly, they did not know how this process operates. And then there was this aspect of mediators shutting them out. So it's not really clear in Kenya the role of a lawyer in court annexed mediation. Judicial officers, yes, in as much as the judiciary is seeing court annexed mediation as a way of reducing case backlog, our study established that in the system, there are judicial officers who are worried about court annexed mediation. They feel that the power of making decisions is being taken away from them. And then we have these members of staff who are worried that, in fact, one was asking me during the study that if we refer matters that have been filed in court to mediation, then what is going to happen to us? We are going to lose our jobs. So those are some of the fear, the resistances that are being experienced. How does it affect the poor? As we say, that the poor person is disadvantaged in terms of information and knowledge. So whenever anyone has a dispute, the first point is a lawyer, an advocate, or a person who works in the court. These are the people who are supposed to to shed light on how the process works. And if they already have prejudices, they are already resisting mediation, then the poor person are not able to enjoy the fruits of this process. There is the issue of lack of standardized training for mediators. Mediators in the house, please, I'm not discrediting you. I'm also a mediator, though not accredited. You find that there are mushrooming institutions which are not controlled, training mediators. There is no quality control. Some are being trained for 2 days, some 1 day, some 1 week, and they have certificates. So the impact or the challenge this has is that it affects the ethics, the standards. And some of the mediators, some of the people who were interviewed had encountered issues to do with mediators' ethics. Some mediators were seeking for bribes from them. So of course, this affects everyone, but it's likely to affect the poor more because the person who is poor is not able to know where to report on how to go about it. So in conclusion, I can see the tall man is moving towards me. I kindly request that you slow down. I'm winding up. So in conclusion, our argument is that CAM in Kenya is a step in the right direction in maximizing access to justice, especially for the poor. I've already highlighted the challenges, but annexing it to the courts or limiting to civil disputes already filed in court has some challenges that has bedeviled the litigation process, especially for the indigent person. Virtual mediation following COVID-19 is commendable. However, it's a challenge to the poor disputant, to the poor. The constant supply, electricity, internet connectivity, as well as ICT is still a dream for indigent persons. So CAM has a potential to achieve greater access to justice, especially for the poor, when the challenges are identified or ironed out. So the recommendation the study makes is that let CAM be made accessible to even disputants who do not have cases in court. We exemplified the Lagos Multi-Door Courthouse, whereby theirs is a variety of mechanisms of solving disputes. So one does not necessarily need to have a case in court. You just walk in, you solve, you are given a mediator, you solve your dispute, and that is it. Yeah? It's binding. So if Kenya can benchmark with the Nigeria, Lagos system of court annexed mediation, so that the poor can also enjoy the benefits of mediation. We also exemplified Ghana. Ghana incorporates traditional methods of mediation in the legal justice system. In as much as we are talking about court annexed mediation, let us not forget that we've been mediating from time immemorial. Mediation has been there. Chiefs, someone was talking about the area, the local leaders. They are solving many cases at the grassroots level. However, CAM does not factor this. So our proposal is that these people, the informal mediators who are more experienced, can be empowered to solve many disputes at the village level. That way, one Onyango or Wanjiku or Mogaka do not have to travel from the rural area to the courts to have their cases resolved through court annexed mediation. And then there is need for resource mobilization. CAM in Kenya largely depends on donor funding. So the sustainability of the process is not guaranteed. So there is need for the government and the judiciary to spare some resources for CAM, and also continuous public sensitization, the poor people on how to access these procedures, even the information. There is need for continuous sensitization. I think that's all that I needed to say. Thank you all for listening to us.
The paper we are presenting, we are co-presenting with Jackie Gashiri, is a paper that seeks to explore the possibilities or the potentials that may be derived from the use of information, ICT technologies, particularly blockchain technology, to improve access to healthcare in Kenya. The dominant theme in discussions concerning COVID-19 and its implications for the health sector has been mostly in relation to its effects and its responses. In relation to its effects, we see that it has resulted in loss of millions of lives, health complications. We find healthcare personnel also suffering. So COVID-19 has led to a perfect storm of misery and inconvenience for human beings. But on the flip side, it has also divided on a context necessity that is conducive to technological innovation, adaptation, and creativity. One of the areas in which this type of innovation can be useful is in the sector of the delivery of healthcare, the management of health information, and the ways in which healthcare can be made accessible, available, and affordable to those individuals of the lower incomes strata. Now, this paper will be divided in a number of sections. There will be a section on COVID-19 and barriers to access to healthcare, which will discuss the legal barriers, the economic barriers, and the institutional barriers. The next section will look at the salient benefits of using blockchain for delivery of healthcare in Kenya. And then the following section will discuss some of the real-life experiences, a comparative study of an experience from India and an experience in Kenya. And then there will be a concluding part. So I will present the legal matters, and then the technical matters on which I have very little competence will be the forte of my co-presenter. So I will start off with COVID-19 and some of the legal, economic, and institutional barriers to access to healthcare. With regard to legal barriers, it's the usual, the two things come in mind. Is there a sufficient framework for statutory regulation? That's number one. And number two, if there is such a legal statutory framework, is there a mechanism for meaningful access to remedy and redress? Now, what our study has shown and what is indicated in the full paper is that, yes, there is quite a progressive legal framework, starting from the Constitution at Article 43, where we have the right to the highest attainable standard of healthcare. The content of the right to health was discussed in some detail in the presentations yesterday, and I would not wish to belabor the point, but only to emphasize that the right to health is interconnected and interrelated in intrinsic ways to other conditions that are necessary for a healthy and dignified life, such as access to clean and potable water, access to sanitation, access to nutrition for children, and so on and so forth, the broad range of socioeconomic rights. And so if those socioeconomic rights are not readily available, and if their mechanisms are difficult to access for individuals who are of the lower income level, then it means that it is difficult for that highest standard of healthcare to be delivered to people in any meaningful sense. And if that is not delivered, it becomes nearly impossible for them to find redress. So apart from Article 43 of the Constitution, we also have important statutory provisions in the Health Act of 2017. We have sections 104 and 105 of the Health Act, which is relevant to healthcare information of patients. I will use a real-life example to illustrate the irony that there is statutory provision, but yet there are significant shortcomings in the way in which effect can be given to them. There is a recent case which is in the public domain. There's a lady who received pre and postnatal healthcare at Nairobi Women's Hospital. I'm mentioning the name of the hospital because it is a matter of public record. It is not to sully their reputation, but merely for illustrative purposes. Now, this lady went there, delivered a baby, but the baby passed on. Now, later on, when she went to the hospital seeking her medical records, she was told that her medical records were either lost, they were unavailable, or were inaccessible. Now, this led to a legal challenge, a court case, in which eventually, after a number of years, maybe 3 or so years, the court awarded her 1 million shillings in damages. And those damages arose primarily because of the mishandling of her medical records. Now, this problem of medical records illustrates the necessity for an innovative way to handle patient records so that they are accessible, they are retrievable, and they are interoperable. Now, the benefits of blockchain technology, which will be explained in greater detail in a few minutes, will be able to
we will be able to show you how some of these problems may be overcome. Coming to economic barriers, it is a fact that during the COVID-19 pandemic, very many people lost their earnings, there were job losses, there were closures of employment opportunities. Some individuals were rendered unwell and unable to pursue any gainful employment, and so on and so forth. So when people have a diminished capacity to fend for themselves, it becomes difficult when they fall ill. Who takes care of them? How do they meet their medical bills? How do they get access to medicines, and so on and so forth? Coming to institutional barriers of access to healthcare, we find that there was a very insightful presentation yesterday by Dr. Ogendi, and he showed us that there are a number of institutions that may be able to play a role, but these institutions are largely less well known to the general public. So even if these institutions do exist, they are statutory creatures created by the Health Act, other statutory instruments. That lack of knowledge presents a barrier, particularly to the people who are the lower income group. This information is not readily available. The knowledge of the existence of this mechanism is very minimal, and so access to them becomes a problem. Now, on that note, I will invite my co-presenter to now mesmerize us with the tech.
Good morning. My name is Jacqueline, as it was written. I am the lead researcher and business development manager for Belfrix, which is a blockchain consultancy. So just one show of hand, who knows what blockchain is? That's not, without touching on crypto. Anyone? Okay, so blockchain is a decentralized database that is used to record transactions that are shared across a network of computers. So for example, everyone here who has a laptop, those are what we consider nodes. So in this room, we can have our own private or public blockchain, which every data that is shared in one computer or laptop is to be shared, each copy is given to each and every laptop. So that creates of communication. And the thing about blockchain that makes it very important for, especially in the healthcare system, it's very tamper-proof. So if a doctor's report is placed in the blockchain, it's shared by everyone in that network, but the data is only seen by very few. So the doctor and the nurses, probably the HOD and the patient. We also give access. Okay, the way we have created our blockchain is we also give access to the patient. So I know there are incidences like all of us who have different, in the medical field, there's siloing of care. So if I go to Nairobi hospital and I'm treated and I decide to find a cheaper option and decide to go to Kenyatta, Nairobi hospital won't give me my file. So that's what we call the siloing of care. What blockchain enables is we can be able to share, me as a patient, I'm able to give access to the hospital, to my medical records. I can choose to give them access for a week. I can choose to give them access for a month. I can choose to give them access for a year, depending on my medical treatment. So just go back. So yes, so blockchain technology actually in healthcare can be used for disease surveillance. I think when COVID was detected, actually the US military and Canadian military had a clue, and they had actually reported that there's an imminent pandemic. And the reason why they're able to do that is because they have something called a medical intelligence unit, which uses data, collected data from across the globe, and they do the analysis. It's also used for patient data management. As we know, patient is bulky, it's sensitive. You can imagine how many patients are there in KNH, and you have to, have their data from date of birth, their names. Though we know in 2018, the incident where they operated on the wrong patient, just because of human error. There were two patients with the same name, and they didn't really, file was missing. So the wrong patient ended up being operated. And for 2 hours, no one in the theater noted this was the wrong patient. So blockchain helps to eliminate such errors. As I mentioned, the granular medical histories from different hospital points. It helps in tracking of diseases. It also helps in the tracking part. There's something called drug traceability. I remember I was in some county hospital a few weeks back, and three things stood out. First was they had a lot of medicine in the store that was expiring. Secondly, a mortuary that handled 12 bodies had close to 100 bodies. And third, their patient medical room was just a room with files. So I remember I asked them what happens if something happens to light fire, and they're like, all the patients, their data goes up in flames because it was in a file in the file room. So yeah, so blockchain also helps in analytics. It can be embedded with the Internet of Medical Things. By Internet of Medical Things, we're talking about meters, we're talking about, all the machines, blood pressure machines, anything, which this has because of ward care. One of the most overlooked sections in healthcare, especially in Kenya, is ward care, where you're in a ward and a nurse is outside, and they come every 30 minutes, every 1 hour. So if anything goes wrong before they come to do the rounds, then it's easily for a life to lost. So Internet of Things can sit in a state and be able to monitor each and every patient through the Internet of Things. Artificial intelligence, which helps with deep learning. As we know, medical is a knowledge-based industry. So, and these decisions need to be made. So they need to have data by their fingertips. Doctors and people in the ecosystem need to have data by their fingertips. Also, artificial intelligence, helps in creation of curriculum, as I said, in research, medical curriculum. I know KNH, they do groundbreaking surgeries. So medical students can actually be roped in via Zoom or Meet or whatever, and they can see in these surgeries without having to be in the theater, which helps with improving the medical curriculum. And it also helps in clinical trial. I think actually Rwanda is really pushing for the use of blockchain because they want to be among the first countries in Africa to start producing their own, drugs. And the reason why they're doing that, they're using blockchain, is because of it helps. There's incoming data, so which helps with the clinical trial. So you have real-time data that is tamper-proof. No one is going to, add a few things along the communication chain lines. So yeah, that's the importance of blockchain. Next. We did a proof of concept. We have a medical blockchain solution. It's called Belio. So we did a proof of concept in India, and it was during the, when there was a surge in India. So the vaccination and the testing of COVID during the surge. For us, when we did the pilot project, we were able to do 30,000, certifications, and our blockchain was dealing with 100 certification a minute. So you can imagine if data, 100 COVID certifications and testing are, information is being churned out, 100 certifications a minute. So from what we learned, due to that pilot project, the Indian government actually asked our company to create a national health blockchain so that everyone can be put in the grid, and then they'll be able to share their medical history with any entity, wherever they are in India, just to make it easier for everyone. Yeah. So in conclusion, we really need to, I think a lot has been said about, technology, but for us, it works, I know the buy-in is usually the most difficult part, but what COVID has showed us that, health is important. You can have everything, but if you don't have your health, then, there isn't really much you're doing. And technology like blockchain is creating an environment where you'll have data in your fingertips, and everyone will have data in their fingertips, with it being private, and secure. We've all talked about the security of data and your personal information. Actually, last year, the American lost healthcare paid $20.4 billion in ransom due to their systems being hacked, the electronic health systems being hacked. But blockchain it's those systems that you cannot hack. And the beauty about blockchain is the more people you add to your system, the stronger your system becomes. So the more people you add into your ecosystem, the stronger your system becomes, which cannot be hacked. Last slide, please. I want to show you guys how blockchain looks like. Sorry about that. And, yeah. So in the screens, I think you can look at the screens. So actually that's how your data looks like in the blockchain system. So this is a public blockchain, but no one can really know what the data is. They can see the header, but it's you to give the private. So you are the only one who can see what that data is. Everyone else in the system, they just see the cryptography of the whatever. So that's how, yes, thank you. So sorry. So this is actually a patient record, but so you cannot see what the person is ailing or any data. But the person in the system who has access, who's been given access to it, can be able to decipher what that data means. Thank you very much.
Good morning, everyone. I actually thought someone else was presenting before me, but it's fine. So, yes, I'm presenting this paper titled ADR as an alternative justice system for service delivery in crisis systems. I'm presenting it on behalf of Mr. Justice Munithia. Who is an advocate of the High Court of Kenya. He holds an LLB from University of Nairobi, LLM also from the University of Nairobi. He's an accredited mediator, the current chair of Kituo cha Sheria's board, the chair of LSK SACCO, and he's a former member of the defunct Judges and Magistrates Rating Board. I hope I'll do justice to his paper. So from day one, we're talking about ADR and alternative justice systems. So in brief, this is just a settlement of disputes using mechanisms outside the normal court process. It is also a broad spectrum of structured processes, including mediation. And I'm also happy that we had a presentation on mediation before mine to create like a base of what I'll be presenting on. So mediation is one of the ADR settlements that people use and conciliation. So it does not involve litigation, but it can be linked or integrated with it. And it involves the assistance of a neutral third party, and it empowers parties to resolve their own disputes. So, ADR has been viewed, and even in the Constitution, it's usually seen as being complementary to the normal judicial system due to its advantages, which have already been mentioned earlier this morning. Affordability, flexibility, informality, cultural acceptance, and the maintenance of relationships. So in terms of crisis, we've said ADR has normally been seen as complementing the normal formal systems in court, but now in terms of crisis, ADR is seen as an alternative to the judicial process. So even before the COVID-19 pandemic, the common law jurisdiction, or how our courts are usually set up, have been seen by scholars as being in crisis for a very long time. You find that this form of litigation or adjudication is considered to be old-fashioned. The processes are obsolete, and they cause delays at the expense of court users. I'd like to share a small quote by Abraham Lincoln, and he says, "Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them that the nominal winner is often the real loser in fees and expenses and waste of time. As a pacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough." So on this issue of wastage of time, we discussed this yesterday when Ruth was asking how long does a whole case take in court, and we figured that it takes a long time, and even other presenters were presented on it. If you can take 5 years in court, you're wasting your time, and if you don't have to be there, you'll actually go for an alternative where you can just solve your issues in a shorter period of time. So in terms of crisis, we saw from the very onset that the system based on personal attendance was not going to work. Initially, though our judiciary worked very fast, thank God they were already thinking of introducing ICT in the judicial systems, so they could actually go ahead and change things very fast. But personal attendance was not going to work. Definitely, initially we had disruption of hearings, cancellations, postponement, and remote hearings. Also, how are people going to follow the judicial processes? How was evidence going to be gathered? And we also had the risks if personal hearings were to be held. I discussed this yesterday when I was talking about one case in particular where the court held that the right to life was more important than people actually going to court for hearing of their matters. So other than that, you find that, as I've already mentioned, litigation is suffocated by unnecessary expenses. And even with the shift to digitization, or including ICT in judicial systems, we saw that it's still expensive and it's still out of reach to a majority of people, leaving corporations and only the wealthy, and some people in the middle class who can be able to afford to go to court and handle their cases using that means. So COVID-19 exposed the fragility of the legal system and how it excludes mainly the poor. So another issue that has always been there, but now when we had the pandemic, it increased, or it was brought out in the light, is the issue of backlog of cases. There are so many delays, and that's why we even have the wanting to complement the judicial systems with ADR as the issue of delays and backlog in cases. So you find it reduces the effectiveness of judicial systems and disenfranchises the citizenry, while also making people look for informal ways of sorting out their disputes, as I've explained. So from research in 2018-2019, the number of resolved cases was 469,000. And then in 2019-2020, the number of resolved cases was 289,900. That is a 100,000 plus difference. So you see the number of cases actually reduced. Okay, we were in a pandemic, but now you see we still have the issue of backlog of cases, because even with the 400, that is not enough compared to the number of cases that are in court every day. So even though we intervened using ICT, still that was a minimal achievement by the judiciary. And then also, backlog of cases, we saw new and novel issues being brought to court. Definitely contract cases increased, yeah, because of issues of frustration of contract, pandemic, also labor cases. So many people were being, how can I put it? Their salaries were at some point in the year, no salary.
Kama kuna watu nilisemanga sitawahi kuwa na huruma nayo ya hospitali. I swear, I'd rather kuwa na huruma na makanga hata mwizi.
To some extent overwhelmed. Hence, there's a need to use an alternative form of actually being able to resolve these disputes. So COVID posed certain risks in delivery of justice. It posed risks in the delivery of justice. As I mentioned, because the face-to-face model was not working. And then also include the restrictions that were imposed by the government. So the first thing, the risk delivery of justice was the suspension of operation of courts. Before the e-filing system was introduced, courts downscaled their public-facing activities. And you see, we have a backlog of cases. So many cases have not been determined yet, but now we have to shut down the courts with good reasons. So still backlog increases. Then also the imposition of restrictions. People could not travel. And also another thing with the imposition of these restriction measures, as we talked about yesterday, you find that some governments used it as a way of, they used it as an opportunity to violate the citizens' rights. For example, the unreasonable force used by the police. So with that, we actually needed the courts to be there and to actually assist in such areas. Then also there was risks in access to justice, especially in criminal matters. You find that to prevent COVID-19 in prisons, visitations were not allowed, and there's also some restriction of movements of the inmates. So you find there was diminished communication between lawyers, interpreters, and third parties. And then also there was limited access to case files due to the restrictions imposed in access to courts and also the police stations. So you see, right, it goes against the right to fair trial, which is also a right that cannot be limited. And in the end, because cases cannot go on without procedural fairness, you find that we go back to the issue of backlog of cases. So the suitability of ADR in terms of a crisis, and in particular this COVID-19 crisis. You find that, and these advantages have already been mentioned by the previous presenter. ADR, you can do it anywhere, as you have mentioned, you can do it under a tree, so it is flexible and then saves on time, and also it's not costly as a formal court or going to court. Then the participation is usually voluntary in most cases. And if you do not succeed in ADR, you can use the information to support adversarial hearings. So there are three main benefits of ADR that make it better during a crisis. First is efficient, as I've mentioned. It saves on time and costs. And then the second point is the ability to resolve disputes amicably and to encourage cooperation between the parties. The solution comes from the parties themselves. Then thirdly, it promotes control over the disputes, because the responsibility to get the methods and to get a good outcome is on the parties themselves. How many more minutes do I have? Okay. So I think, and I'm saying it has already been mentioned because of the first presenter. So it's, at least you're not hearing this for the first time, and now I have to rush. So ADR is a consumer, it's actually a consumer-oriented method, while you find the court is a public-oriented method. Here we are, the parties are finding solutions or arriving at solutions on their own, while in court or in litigation, we're looking at uniformity and transparency. So you find in ADR, it is flexible and private, and it can be modified to suit a particular dispute or person. Since it is private, but comfortable, it allows discussion, and then also it's easily discretion of the decision maker, because you see they're only accountable to the parties and not to the public at large. Then okay, let me go to the challenges of implementation of ADR. And one of the points mentioned by the previous presenter is the lack of uniformity. And this can be, uniformity or, uniformity in training. And this can be linked to the fact that we do not have adequate legal provision. We have some different acts that touch on ADR, but the Alternative Dispute Resolution Bill 2019 and the Mediation Bill 2020 have been published, but they are yet to be passed into law. And this is because of the absence of political will. So when they are passed, at least we can have a laid out framework that will lead to mainstreaming of training and harmonization of ADR practitioners and funding of ADR programs. So the acts, I can just mention very fast the acts that talk about ADR here and there. We have the Civil Procedure Act, the Marriage Act, the Nairobi Center of International Arbitration Act, the Court Annexed Mediation, CAM, Pilot Project Rules 2015, we have the Employment Act. Yeah, so those are the challenges. And then best practices that we can get from selected jurisdictions. You find that during the time of the pandemic, okay, we are still in that time. I don't know, I think that we've passed that period, but amen. But you find that China's option was to create an internet arbitration system because of the increase in disputes. And then the Hong Kong Special Arbitration Region launched an online dispute resolution mechanism to be able to solve disputes in micro, small, and medium enterprises. Many other jurisdictions like Australia, Canada, and New Zealand have now created mandatory ADR programs that have removed ADR being voluntary. Way forward, establish political goodwill so that we can get the passage of these key statutory instruments that I've mentioned that will regulate and address every aspect of ADR. Then we can make ADR mandatory in our country as a precondition before commencing of a suit. This will benefit the whole litigation process because it will reduce the issues that the court will pass if a case actually gets to the point of going to litigation. And then lastly, passage of the ADR litigation that I've already mentioned. Thank you very much.
Thank you so much. Thank you so much and good morning. I would like to thank Dr. Ruth Aura and the entire follow-up team for extending an invitation to this auspicious occasion to present my musings on the subject of emergency measures without the declaration of emergency, Kenya's COVID-19 experience. I will be brief and look forward to building on this discussion with you. This paper observes the parallels and similarities between COVID-19 containment measures and the emergency measures envisaged under Article 58, that the containment measures achieved the same effect as emergency measures without actually going through the farce of declaring an emergency, which in the absence of parliamentary checks and scrutiny raises concerns for rule of law, given the few instances of executive overreach that were witnessed. My thesis will be that shifting towards a principles-based system and away from the currently predominant rules-based framework could perhaps probably provide a suitable foundation to guide government action in future emergencies, while ensuring alignment with the Constitution's Bill of Rights, including access to justice in such difficult times. My name is Moses Mushiri. I am an advocate, a state counsel currently attached with the Council of Legal Education, and occasionally a perennial heretic. Moving on. So in the few minutes that I have, I am inviting you to think through with me on the broad impact of COVID-19 on constitutionalism and the rule of law, and perhaps reflect on the role and construct of law broadly in times of emergencies. Asking ourselves the question, how do we defend and invoke rights against a government that unfortunately has not had a perfect, clean track record in upholding rule of law in Kenya? So that, moving on, thank you. Apart from being a public health emergency, the COVID-19 pandemic was and still remains a crisis of rule of law and human rights. We witnessed curfews and lockdowns and restrictions on movement, which curtailed access to justice through a variety of largely subsidiary legislation. And there are a variety of legal notices which I have elaborated out there, which the lawyers in this room, you're all familiar with. In fact, you will recall that advocates were not even in the initial list of essential service providers in Legal Notice 36 of 2020. And it was not until Justice Korir in Law Society of Kenya versus Inspector General of Police that the CS Interior was ordered to amend that schedule to include advocates as essential service providers. Moving on, I don't know if you'll remember that map that is on the screen before you. The lawyers in the room probably will, but for the first time in this country, we witnessed raw state power. State power. State power. This map was it still remains in the public health COVID-19 restriction of movement of persons and related measures, popularly known as the Nairobi Metropolitan Area Order, which secluded portions of portions of Kajiado, Kiambu, Machakos, and also Nairobi counties for purposes of the lockdown. And similar lockdowns were witnessed in Nakuru and Kisumu counties. But then what happened after these initial legal notices were published? Reports of abuses and unlawful state actions in enforcing containment measures started surfacing. Reports such as this started becoming commonplace. Move on, just move on quickly. You remember that incident, the sick baby who died in traffic? And also this, just think about that title for a minute. The Kenyan president apologizing for police violence. The Kenyan head of state. What an irony there. Moving on. I think you remember that picture was in Uganda at the very crossing. And many others. And this picture next trended worldwide. That man who was being beaten. This. Now I ask you, how different was this from the 1982 pictures that we witnessed? Moving on, that one, for instance, and that one. And how close we came to actually having a very serious constitutional crisis in this country. Moving on, a picture that we all know. I think you'll all recall that picture. The late night burial of the late James Oyugi by Siaya County health officials. Contrary against traditional customary dictates and of course the dignity of the person. And this was the picture, the subject of the case in John Akoth Juang versus Michael Osodo, where it was held that the right to dignity prevails even after death. And you will remember this well. Forced quarantines, disorganized, no testing, no basic necessities. Kenyans left to fend for themselves and risking exposing the unexposed to the virus as well. And finally, one last picture there from one of those forced quarantine members, a plea for help. I chose that as a last picture because it's actually a cry for help to us who are seated in this room and even outside this room. As you reflect on that, Professor Gross made a succinct observation that in times of crisis pose the greatest and most serious danger to constitutional freedoms and principles. And that in such times, the temptation to disregard constitutional freedoms is at its zenith. In times of crisis, it is often argued legal niceties may be cast aside as luxuries to be enjoyed only in times of peace and tranquility. Yet, it's precisely in such times that constitutional safeguards for the protection of rights and freedoms and liberties are put to the test. A continued commitment to preserving and maintaining rights, freedoms, and liberties ought to be reconciled, note this, with a caution against turning a constitution into a suicide pact. I think about that last sentence, the Constitution as a suicide pact. That Professor Gross saw that while constitutional freedoms and rights must be upheld always as part of rule of law, but that this should, on the flip side, not translate into bottleneck against necessary actions and measures, especially in emergencies and national crisis. The Constitution as a suicide pact. But then let's think through these questions. How can deviations from constitutional norms, including rights, be justified? And what exactly is it about emergencies that warrants deviation from constitutional guarantees and norms? And as you think about that, think about this. How do we achieve that balance between constitutionalism and rule of law, including preserving rights and freedoms, versus the need to take precautionary measures and to ensure that governments are not hindered from taking necessary measures in emergencies and crisis periods? So I'm moving on. The adoption and use and enforcement of COVID-19 measures had the same effect as emergency measures without the attendant declaration of an emergency under Article 58. And those instances of executive overreach raised questions not just about the legality of those measures, but also the legality in the manner in which they were enforced. It was alarming that subsidiary legislation was the vehicle of choice. Moving on. to pass a raft of limitations to rights and freedoms devoid of parliamentary scrutiny. And this is my thesis, that this state of affairs is actually the weakness of the rule-based framework, and the reason which perhaps a shift towards a principles-based framework may be necessary. So Thomas Hobbes and John Locke, to the jurisprudence among us, the theory of social contract, which is a political theory, not a legal theory, is based on several assumptions that people are capable of rational decision-making, and that power will be exercised in the interest of the collective individuals. But it is precisely during emergencies that these assumptions underlying the social contract theory are exposed, and that states actually have the propensity to take advantage of emergencies to abuse power. And therefore, unchecked exercise power can lead to disastrous consequences, some of which we have witnessed. Cases in point currently going on. In Ethiopia, you are all aware of what's happening there. There is a state of emergency currently in Ethiopia, and there are atrocities that are being committed by the government against the Tigrayan people. In Myanmar, the arrest of Prime Minister Aung San Suu Kyi and others. Emergencies expose the weaknesses of this theory right here, the social contract theory, which is why Mr. Fuller came up with what is the internal morality of law to justify laws and the legality of laws on the basis of a set of 8 principles. Now, I draw your attention to the fact that Fuller's principles are the basis of rules. Principles are the basis of rules, and therefore rules derive from principles. I would like to demonstrate this with a recent High Court judgment in the Coalition for Violence Against Women versus the Attorney General and others, where the Constitution held that the state could be held liable where violations of rights protected and guaranteed by the Bill of Rights were proved, even where those violations were occasioned by state actors, by non-state actors, provided that the duty of care was properly activated. Language that we have seen in equity and trusts and agencies and inherited from Donoghue versus Stevenson. Moving on. So, apropos Fuller's principle of legality, Kenyan courts adopted the precautionary principle to justify COVID-19 interventions, which limits rights and freedoms. But courts have also attempted to temper indiscriminate use of the precautionary principle with the legality principle. I would like to offer those 2 cases for examination. That is the case of John Akoth versus Michael Owuor and LSK versus Hilary Mutyambai. So moving on, Article 24 of the Constitution is the basis of the principle of legality. And this has been expounded in a 4-step test that was pronounced by the court in LSK versus Hilary Mutyambai and others, that for laws to pass, for limitations on rights and freedoms to pass the legality test, they have to, number 1, be prescribed by law, be legitimate, number 3, they have to be proportional and necessary, and finally, they have to be made in an open and society. So moving on, and this is my conclusion, that historically in this country, the Constitution was viewed as a conglomeration of rules, not rules, but that following the 2010 Constitution, emerging jurisprudence is revealing a new fresh breath of air, a judicial trend towards viewing the Constitution as a conglomeration of value-based principles. Consider the High Court's recent judgment in David D. and others versus the Attorney General, popularly known as the BBI judgment, where the High Court recognized, among other things, that for the first time in this country, the basic structure doctrine can be invoked to prevent amendments to the basic structure and what the court was calling the eternity clauses of the Constitution. If that is not fresh jurisprudence, I don't know what is. As we know, that basic structure doctrine was upheld by the Court of Appeal. And therefore, ladies and gentlemen, my conclusion is that moving toward a principles-based framework anchored at Article 4 to guide rulemaking may perhaps elevate law to that higher ideal and thereby closing ranks with Longpuller's internal morality of law. And that adopting this principles-based system under Article 24 is a guide to future rulemaking, especially in emergencies and national crises, and a step towards realizing the progressive but often elusive ideal of rule of law, including access to justice in emergencies, not just as the conscience of law, but as a rhetoric of law. Thank you so much.
The moderator made a comment about the process handled by Justice Dulo. And I just wondered whether it's the proper for us to insinuate that court annex mediation should also include criminal matters, because the nature of criminal law is usually public interest, you know. The bad people, the worst of the worst, and the state has a direct stake. What that means is that you cannot abscond or you cannot donate that power to private individuals so that negotiation happen and a decision is adopted as though that matter is settled. So in my mind, it doesn't sit well conceptually to insinuate that criminal law can also benefit from this process. And I agree with her that maybe this should be restricted to civil matters, which is private between individuals. That's number one. For Mushiri, I think I love your presentation and the pictures were so vivid when you brought in the 1980s and the 2000s, the pre-constitutional 2010 era is almost the same. So I want to ask you whether you think the decision by the Kenyan government to use the public order, you know, approach, because there were attempts to bring in the, you know, other approaches, including enacting a legislation. But we used to see public order act orders, yeah? The national security used to give guidelines on how to handle this COVID. Is that a principle-based approach? Because I think that is also a position a government can take. And we usually sometimes overemphasize maybe rights or other frameworks. And then when other approaches are taken, we maybe complain. But that, to me, also can be just a principle-based approach. Thank you.
We now go next to Dinaura.
Thank you. My question goes to Dr. Sang and Jackie. It's about the issue of inscription. I've seen you've said that your system is foolproof. Okay. I really needed to understand, because I've seen even messages that we see on that is protected by WhatsApp, they're encrypted, but they still find their way into other systems. And you know, medical records are very sensitive and highly, you know, you can really be exposed if someone gets access to your information, including that, including making the patient have a mental or psychological things that can lead to an worse health system. So I would just want to understand how you're able to, you're going to prevent you're going to ensure that the information is kept as confidential as it could be. Well, I also appreciate that the dangers of having the hard copies, they can get lost, they can be burned in the fire, but how sustainable can this one of yours be, including that sometimes systems collapse and you'll not be able to have any backup? Thank you.
We have a hand behind. Let's start with Diana. We move on to her sister next to her, Mwalimu next, Mutembe, and then the final Baba Rotich, then the brother behind there, and then we will respond to those before we move on. So the rule remains short and sweet. 2 minutes, ni more, ni plus, no more, no less. Diana.
Okay, I'd like to add to what Ogada has sparked and what Paul has mentioned. And I would like to hear from Dr. Scholastica because she taught me criminal law in undergraduate. And she told us that in criminal cases, it is republic versus the accused person for a reason. The victim is a third party who is kind of like on the side. The matter is against the state and a person who's done a particular wrong. And I know, yes, reconciliation is provided, but it is only in matters that are not felonies and matters of private natures. So my question is, if we let felonies and other aggravated, cases of aggravated natures be handled by mediation and other ADR mechanisms, are we not letting, or are we not opening a Pandora's box? Because in the example that you've given, where the family of the victim is paid off by gods, I just immediately thought of the issue of Babu Owino. If that issue is taken of DJ Evolve and Babu Owino, if it's taken to a mediation settlement and the family is told, we'll give you 5 million, if the family is poor, they'll say, okay, let's just settle this matter. So I'd like to hear Dr. Scholastica's views on that issue.
Thank you. I'd really like to appreciate the presentation by Jackie and Tim. Very timely because technology is something that we can't run away from. Particularly for those of us in litigation, we know the value of timely evidence. And sometimes you go to hospitals to get medical records and you're given a story and doctors really just don't care. So perhaps just my main concern, and I'd really be interested to know, is there any salient challenge that presents whenever you try to approach perhaps public institutions, especially where there's, a problem with record keeping, that perhaps you just want to let us know so that we just, as we move forward, we know how we can